All right, welcome everyone. My name is Ryan Susky. I'm Director of Programs over at the Ohio Center for Law-Related Education, and I'll be serving as the facilitator today for the Unit 4 hearing for Fall Creek Junior High School for the We the People National Invitational. In just a minute, I'm going to have the judges go ahead and introduce themselves, followed by the students, and then we'll begin the hearing. The process for the hearing today is that students will deliver a 4-minute prepared statement, followed by 8 minutes of follow-up questions. Now, I'm going to have my microphone muted during the hearing, but I will be holding out time cards for the students. For that reason, we do highly recommend that you go ahead and put your computer on gallery view so that you can see my time cards and, of course, your colleagues during the hearing. Once we're finished, the judges will give brief feedback to the students, and then we will conclude. With that, I'll go ahead and hand things over to your chairperson to begin the introductions.
Okay, well, thank you, Ryan, and good to see you again. You know the routine by now. We'll introduce ourselves, have you introduce yourselves, make sure no one has changed their name overnight or that we haven't had people cut from the team or draft choices taken or things of that nature. And then we will turn to the question at hand. My name is Joe Stewart. I teach in the political science department at Clemson University in South Carolina.
Hi again, I'm Diana Owen. I'm a political science professor at Georgetown University in Washington, D.C.
Hi, I'm Deshawn Whitaker, We the People teacher in Charles County Public Schools in Maryland.
Please introduce yourselves and your teacher.
We are Fall Creek Junior High's Unit 4. I'm Gwyneth Gephardt.
I'm Jacob Shade.
I'm John Harold.
And I'm Daniel Serrano. And our sponsors are Patrick Bradshaw and Jeannie Medeiros.
Okay, great. It's good to see you again. Well, no surprise, this afternoon we want to talk about question 2 in Unit 4. And it is a quote from political scientist Robert Dahl, who says, if a law has been properly passed by the lawmaking branches of a democratic government, why should judges have the power to declare it unconstitutional? Do you agree or disagree with Robert Dahl? Why? What is judicial review and why is it controversial? What has been the impact of judicial review on American society? Once the Supreme Court has decided that a law is unconstitutional, what power, if any, do the people have to change the Constitution? You may begin.
We disagree with Robert Dahl's statement and believe the judicial branch still plays an important role in the lawmaking process. The reasons include judges' power and decisions in court and outside opinion on whether it's constitutional or not.
Judicial review is a process where the United States Supreme Court can determine the constitutionality of a governmental act. This ability gives the Supreme Court and the judicial branch in general great power in deciding what remains legal in this country.
In 1803, Marbury v. Madison established judicial review when William Marbury was appointed Justice of Peace in the District of Columbia under the Judiciary Act of 1801. Chief Justice John Marshall declared Marbury's claim to be unconstitutional since it was based on the Judiciary Act of 1789.
Some, like Dahl, find judicial review controversial, arguing it goes against the Constitution since Marshall gifted the court the power to do so in Marbury v. Madison. They argue if the founders wanted the Supreme Court to have judicial review, they would have written it in the Constitution.
They fear that too much power is being given to the judicial branch. Don Willett stated, if judicial review means anything is that judicial restraint does not allow everything. This is stating that judicial restraint keeps just anything from being passed.
Judicial review has had a long-lasting impact on American society by expanding the powers of the judicial branch. After Marbury v. Madison, judicial review expanded. In Martin v. Hunter's-Lessee in 1816, the Supreme Court ruled that the Supremacy Clause, stated under Article 6, Clause 2, in the power of appellate jurisdiction, gives the court the power to review state court decisions that interpret the Constitution. In 1821, Cohens v. Virginia, the court concluded that it has the authority to review state criminal cases. Martin v. Hunter's-Lessee and Cohens v. Virginia were important cases in establishing the supremacy of federal over state courts.
In Cooper v. Aaron, the Supreme Court ruled that all states are bound to the rulings of the Supreme Court because of the Supremacy Clause. This clause makes the Constitution the law of the land.
Judicial review's impact on the American society goes beyond the judicial branch's additional powers, but to civil cases that protect citizens' rights.
In the 1954 case, Brown v. Board of Education, the Supreme Court declared separate but equal facilities are inherently unequal and are a violation of the 14th Amendment's Equal Protection Clause.
That overturns Plessy v. Ferguson, a case that introduced separate but equal facilities in 1896. In Loving v. Virginia, the Supreme Court decided it's unconstitutional for a state to infringe on the right to marry anyone of any race. Brown v. Board of Education and Loving v. Virginia were important turning points in desegregating the country.
When a law is unconstitutional, it means that the law in part or in its entirety is contrary to the Constitution and thus void. The power that the people have to change their constitution has been difficult. This is partially because of the support they need to change a document that governs our country.
Since the ratification of the Constitution in 1789, the Constitution has been amended 27 times, and, as stated in Article 5, an amendment is added if 2/3 of both the houses or 2/3 of the majority of states agree.
This is also because the judicial branch is meant to balance the other branches and not let any one party or group take control. They do this by unbiased rulings based solely on whether or not it abides with the Constitution.
There's one thing that people can do to help the future by voting in officials that have similar viewpoints to their own so they can help pass beneficial bills in the House. Representatives should be closer to the people they represent so they know what the people who vote for them need. By doing this, they can legally alter the outcome for courts' decisions on future cases.
Judicial review is the deciding factor of whether or not the law is abided with our Constitution, which is very important to keep our country balanced, stable, and fair. As John Marshall said, it's empathetically the province and duty of the Judicial Department to say what the law is.
We are now prepared for your follow-up questions.
Okay, well, thank you. You out that the Constitution has been formally amended 27 times. Is that the only way the meaning of the Constitution has changed? Or are there some other ways that it's changed?
There are some other ways that the meaning of the Constitution changes, such as in Supreme Court rulings. This is seen in 1896 with Plessy v. Ferguson, with the addition of separate but equal facilities.
I respectfully disagree with my colleague Jacob. I believe the Constitution its change is based on solely just the amendments, and the Supreme Court is kind of not solely, it's based on whether it abides with the Constitution, and the Constitution is based on amendments that don't infringe on citizens' rights.
To add on to what my colleague Daniel is saying, judicial review does not add or remove anything from the Constitution. It simply enforces the Constitution.
I agree with my colleague Jacob, and to add on to that, the Supreme Court's rulings can add to the Constitution, not necessarily just the amendments, because in the court's decisions, you can see that the decision was important.
So in your prepared remarks, you mentioned that the judicial branch balances the other branches. Can you explain what you mean by that exactly and give a couple of examples?
Judicial review is a check and balance for the legislative and executive. In our current state of a government, for example, the executive and legislative branches are both Democratic-led, but our judicial branch is conservative.
You can go ahead, Daniel.
To build off of what my colleague Gwyneth was just saying, judicial review is a great example of what check and balance to keep the other branches safe and balanced, such as in the case Lade v. Giglio. Giglio was putting up signs to stop war in the Persian Gulf. The city of Lade told her to take those down, but that is indeed a violation of her First Amendment rights, and that wouldn't have been stopped without judicial review.
Adding on to my colleague Daniel, as Alexander Hamilton wrote in Federal 70, the judiciary, on the contrary, holds no power over either the sword or the purse, but merely judgment. This is saying how the judiciary does not enforce its rulings or create new bills or laws, but merely provides judgment on cases that comes to the court.
All right, thank you. Do you believe that judicial review is critical to protecting the rights of the minority against the will of the majority?
I do think it is important to help the minorities. We see this in the case of Cohen v. California. Mr. Cohen had some vulgarity on his sweatshirt and was sentenced to 30 days in jail because of California's law and statute. But it went to the Supreme Court, and the Supreme Court decided that this was in fact a purge on and an infringement on Mr. Cohen's First Amendment rights.
We also see this.
Gwyneth, you may go ahead.
Thank you. We also see this we also mentioned this in our paper, Loving v. Virginia and Browning Board of Education, both of which were violations of the 14th Amendment and both of which were protections of minorities, specifically African Americans.
Adding on to my colleague Gwyneth, another example of the Supreme Court protecting minority rights is in the case the Regents of California v. Bake, where Bake was applying for medical school at the University of California, but was denied when 2 years in a row, even though students who were minorities had lower test grades and were allowed in. The court was still protected the minorities' rights by allowing them a number of positions to make sure that the majority does not overcome the minorities.
When we're talking about court rulings telling us what the Constitution means, what are we to make of the split decisions? If we get a 5-4 decision, 6-3, does that mean we don't know what the Constitution means, or how do we interpret those?
So, like you said, a lot of people interpret things very differently. And so judges are humans themselves. And so some may view the Constitution in a different light than others. And so that's why we see the split decision. Doesn't mean that one side maybe is necessarily wrong or the other side is. It just is saying that like the majority thought that this case was wrong or this case was right.
Adding on to my colleague John, there are two main philosophies that judges have, either judicial activism or judicial restraint. Judicial activism is where the judges view the Constitution as like a living constitution and apply it to modern day times to keep it relevant, while those who use judicial restraint use it when the Constitution was written and view the same ideals as it was written.
Do you think that the Supreme Court justices should be elected by the people?
I do believe that the Supreme Court justices should be elected by the people, considering the fact that the controversy around judicial review is that since we are such a citizen-based country, having a branch that makes major decisions like in Roe v. Wade with abortion with 9 unelected judges can be considered very controversial. So allowing people to vote in those people, I think would allow for those big decisions to be less of a controversy.
I respectfully disagree with my colleague Gwyneth. I believe electing judges based on the citizens would just make judicial review more controversial. After all, judicial review's whole purpose is just to see if something abides with the Constitution or not. There's no need to make it more political and based on political parties.
All right. What are your thoughts on the life term of the justices?
I think that the life term is a good way to have the judges, because I do not think it'd be good to have them worrying about a re-election to fulfill their requirements.
I respectfully disagree with my colleague Jacob. I do not think that is a good thing because we never get to see these people actually in physical action. And if we look at the newly elected Supreme Court Justice ACB, she only had a few years of experience in the judicial department. And I think having her being on life, especially her young age, can be is a little weird.
To add on to what my colleague Jacob said, I think it should be for life, partially because doing a job for a long period of time can help add experience. Plus also having that experience and knowing previous cases because you were in there for a long time. May I please finish my comment?
Yes, please do.
So being in there for a long period of time, you can develop a lot of knowledge of other court cases that you've served on, and you can use that knowledge in the future to help other court cases.
Okay, well, thank you.
Thank you.
We really enjoyed our discussion today. I thought you did a good job of clearly stating your position of Dahl's comment, and then a large number of appropriate Supreme Court cases that were tied into this. There are other kind of informal means of amending the Constitution that probably help us explain why we've only had 27 amendments. But what you said was certainly correct. You didn't fall into the trap that a lot of people do of equating activism and restraint with ideology, that there can be conservative activism as well as liberal restraint. It all starts on, it all depends on kind of where we're starting. But I really found this a very productive and enlightening discussion. One of the things I would say is there are no constitutional qualifications for being a federal judge. And while not everyone will learn from experience, some people just get older. I would think that each of you is well qualified. You have clearly put a lot of thought into this, and I'd be happy to support you. And if you can get yourself on the federal court anytime soon, I'll talk with your coaches and teachers and make sure you get an A in this class, I promise. So thank you very much for this discussion.
Thank you.
Thank you.
Yeah, I really thought you had a very strong opening statement, and you did a really great job of responding to the follow-up Q&A. I appreciate the fact you started out by stating right from the start clearly that you disagreed with Dahl, and then you made your case for it as you progressed through your prepared statement. What I really appreciated was the fact that you made a point of defining the key terms that you were using. You did so clearly, and you did it not only in your prepared remarks, but also in the Q&A. Your definition of judicial restraint and judicial activism, I think, was the best that we've heard all day. And that was, people were confusing that with kind of political things, as opposed to you hit the nail right on the head with that. I liked in your statement how you made a great use of the court cases, and you clearly knew them well, and the history that you laid out on the evolution of judicial review, starting from Marbury and how it progressed, and how, basically that power has been enlarged over time, I thought was really great. You have a good sense of how political reality plays into, the whole operation of the Supreme Court, particularly around judicial review. And I thought that you brought that in where it was relevant, particularly in response to the questions. And you, of course, sometimes you built on each other's statements, other times you respectfully disagreed, but that was really helpful in terms of providing a range of perspectives. And so I thought you did a really great job, and it was great to see these past 2 days.
Thank you.
Thank you.
Thank you.
Yes, I agree with everything my